Property ownership discussion can be found in Chapter 4 of the Farm Transition material. The way property is titled on a deed can and will have a direct impact on how it can be transferred at a later date. Important that we understand how this interaction occurs, the different ownership forms, and the limitations that can occur when that property is to be transferred to someone else. So how can real property be owned? Fee simple, that's complete ownership. Basically, the mine situation. It's all mine. Nobody else has any control. A life estate. Use the property for life, then provide an avenue to give it to somebody else. There's also co-ownership issues. Typically, we see co-ownership, tenancy in common, joint tenancy, and the very rare case of tenancy by the entirety. In Oklahoma, that's pretty much a point that's long gone. So the ones we see the most are tenancy in common and joint tenancy. So what's fee simple absolute? That's that mine situation. It's potentially perpetual in duration. You'll own it until you decide to sell it or transfer it. It's not subject to any conditions. However, there are certain things imposed by the government, for example, dumping, etc., that's not allowed. So for the most part, you can utilize it any way you wish, as long as you do not do things that are illegal or accepted by the government. Since all ownership rests with the owner, property goes nowhere at death without some force acting on it. That being either the probate process or a trust document that then directs how that property is transferred. A life estate. Basically, there's two parts to a life estate. You have a present estate or present interest. That's defined by someone's life. A future estate or future interest that rests upon the event of death, that becoming the remainder. So the creation, you have two ways of doing it. A granted life estate, which we've presented here. You create it to grantee number one for as long as he or she lives. So I have the property. I grant it either to myself or someone else. And then upon death of that person, then it goes to another individual, grantee number two. Or grantee number one for as that person is alive. Strings attached to a life estate. These can occur. Holder of a present interest may not deprive the remainderment of their interest. In other words, they can't convey it, sell it, etc. There are certain things that has to go to the remainderment. That also includes any leases, etc., that are existing on the property at time of death. The holder of the present interest prohibited from committing waste, abuse of the property, letting it run down, not maintaining it, etc. So, has to be maintained, has to be taken care of by the current interest owner or holder. The holder of the present interest, again, cannot convey the interest until death. It goes to the remainderment. They can't make it go to somebody else. A will can't act upon it to say, I don't want the remainderment to have it, I want somebody else to have it. It has to go to the remainderment. Tenancy in common. Basically, each owner has an undivided interest in the whole property. Creation usually occurs when property is conveyed to multiple parties with no further instructions. In other words, I want sons A, B, and C to inherit this piece of land. There's no specifications as to what portion of that land they get, what 80 acres, how it's divided, etc. They each own an undivided interest in the full property. Each interest can be sold or inherited separately. However, it can cause problems when one or more of the owners want to convey it separately. So, in other words, if I want to sell my interest and I hold an undivided interest, it may not be as easy to sell that as it would be if I could actually lay bounds upon the property that I own. So consequently, when we have tenancy in common, there's often a situation where it is not easily sold or conveyed on a separate basis. Usually has to all be done at once. Can get extremely messy when more than one generation is involved, because the parents owning the property then the next generation gets a hold of it. They may not see the same things the same way as the original generation, and they may wish to have their parts sold off, get out of it. So it creates some issues where we may have some problems trying to resolve who has ownership of what parts, etc. So when you look at tenancy in common, it does create an equal distribution, but it also can create some other messy situations when one of the parties wants out of that tenancy. Joint tenancy with rights of survivorship. Very common among married individuals. Basically, co-tenancy with a survivorship function. What that means is joint tenants. The surviving joint tenant receives the property. Can't be conveyed to anybody else. Interests always are balanced, each owning a equal share. Their surviving joint tenant receives the interest of the decedent, so no matter what happens, whoever dies first, it goes to the surviving joint tenant. No ifs, ands, or buts. A will has absolutely no effect on the property transfer process because joint tenancy, by its name, has to go to the surviving joint tenant. A will or trust cannot have impacted, so a life estate, testamentary trust, has no impact. Upon death, the surviving joint tenant will receive title to the property. A problem that can happen, disinheriting children should a surviving spouse remarry. Husband and wife own a farm. Husband passes. Wife inherits the whole 160 acres. Wife then remarries. Their original children can be disinherited should the wife pass before the new husband if they put it in joint tenancy at that time that they married. Consequently, you really like to look at this because joint tenancy always goes to the surviving joint tenant. We can get the situation where that property passes outside of the original family. Transfer on death deeds. Basically, it's a method of doing a property transfer, avoiding a life estate, also avoiding the problem of desk drawer deeds. In other words, we take a deed, we draw it up, we throw it in a desk drawer. When I pass, the children need to go file that deed at the courthouse. There are some issues that can occur with that. One, they can't find the desk drawer where it was held. Other situations, it may not have been a valid deed in the first place. So by doing a transfer on death deed, we get an alternative to those problems. Transfer on death deed, filed at the courthouse, it can be revoked or changed at any time prior to that creator's death. Upon death, it becomes active. Prior to that, it can be changed, it can be done away with, as long as the original owner does it. Like I said, it does not convey any interest in that property until the death of the grantor. Prior to that time, anything can be changed. It cannot be revoked by a will. So if you create one of these and you forget about it and you put together a will at a later date, that transfer on death deed holds. So how does it work? You draft a deed describing the property that's going to be transferred. You describe the person that's going to receive it upon death. You sign and notarize the deed. Then it is recorded at the county land records office, and it has to be recorded prior to the death of the grantor. It can't be thrown in the desk and then waited till later. It has to be done prior to death. So the beneficiaries, what do they have to do to claim their property? Well, they have a certain amount of time that they have to get this done. So if you're going to create a transfer on death deed, you need to tell the beneficiary that it exists. Then that upon death, they need to go to the courthouse, county land records office, file an affidavit, basically stating that they are to receive it. Death of the grantor has occurred. Whether that grantor or grantee were husband and wife, the legal description of the property has to be filed within 9 months of death. If not, property reverts back to the estate, and then any estate documents will have then the action upon that, that being a will or trust or rules of estate succession where we don't have a will. Warnings. Property transferred by a transfer on death deed, still considered as part of the grantor's estate for estate tax purposes. Even though we have the deed in place, it's still mine. still in the owner's property until death occurs. The beneficiary does not take the property until death, and at that time they take the property subject to all claims on the property. For example, if there is a debt owed to a bank, they take the property with that debt included. The use of it must closely coordinate with your existing estate plan to avoid any conflicts. For example, if you set up in your will and then you later put together a transfer on death deed, the will does not have an impact on it. You may create some situations that you did not think about when you created the deed. So be very careful that you don't have something in the will that is negated by the transfer on death deed. So in review, title of property, got to look at how it's titled to determine what tools can be used to transfer ownership. Like I said, if you've got joint tenancy with right of survivorship, no matter what you do, there's nothing that can be done that will change who gets it. Has to go to the surviving joint tenant. Important to understand the various methods available to transfer the property and the income and estate tax consequences that exist. For example, in another session we talked about estate tax tools, gifting. If you gift property away before death, there are some income tax and estate tax, gift tax consequences that can occur. Really talk to your accountant, get sound legal advice so that you have an idea of what's going to happen before you do it. So be sure to enlist competent legal tax advice, evaluate the options, make sure that you fully understand the pros and cons of your decision before you make the decision and put the action into place. Again, for more information on the farm transitions and the coverage of property distribution tools, go to the website, look at the handbook. It's available for further detail and downloading. Thank you.